Persist. This is connected with both sides are represented. Mr. S.K. Talukdar, legal counsel for the petition applicant, submits that this matter is connected with WBC, with review petition. Review petition cannot be 8,000. Filing, okay, connected with review petition under filing number 8944 of 2025. So accordingly, it is said that both the matters be taken up together. Next, brother. That this matter be listed on, make it next Wednesday, 25 or 26, 8/26, along with review petition under filing number 8944 of 2025. Yes. Yeah. Yeah. Okay, both sides are represented on the prayer made by the counsel for the petitioner. Matters from Judge John today, based on 24/8/2026. Okay.
Promotion, item 1.
Okay. Enter. The writing board requisition query. Writing board. Board at the writing board. ये तक board से था ये तो requisition query रखी गई था. Yes. Which page is the opinion? 122. Just a moment. Yes. So when you were moving this matter, you should have asked us to about this, and therefore we would have called for both the records. Because you never, the court never recorded that.
So earlier proceeding, he was so earlier she was as proceeded.
Sohra. Which page is that opinion? Fifty-eight.
58. Your contention seems the safest. You need the other record.
Both sides are represented by referring to annexure 16 to the writ petition, comma, the learned counsel for the petitioner submits that the petitioner was earlier declared to be not a foreigner. Accordingly, the court is inclined to call for the records of FT case number 69/2008, arising out of SP within bracket B, bracket case number 1294/2004, dated 21/3/2005, which was disposed of by opinion dated 22/5/2009, passed by the learned member, foreigners tribunal, Sonitpur, page 4. This, Mr. Pine, this Sonitpur, Tejpur would be now foreigners tribunal 1. Page 70, 70. You know, yes, sir. Mr. J. Pang, understanding also for the border and matter submits that in all probability the records will be lying with the.
It seems, my lord, if you lordship may kindly see the right below in the page 70, left side one,
Yes,
exhibit 3, or this is by FT number 8. Where from the certified copy was obtained? The
this is obtained from.
Matter now, the jurisdiction of such matter of Elamora falls under the tribunal that is.
No, the certified copy was issued by the foreigners tribunal, Sonitpur, Tejpur.
2009.
What is it?
Foreigners tribunal, that one, Sonitpur, Tejpur. For the special and the requisition to be set down at tribunal through email at the through the following email address. Next, madam. Based on so awaiting receipt of the said records. After 3 weeks, the date.
Item 3,
Yes.
Earlier case where issuing notice and will keep it in the admission stage.
My lord,
In the earlier matter,
Yes,
they'll
ma'am.
issue notice and keep it in the, you are there, you keep it in the admission stage.
yes, let it come on the.
Before that, you said that in your the issue raised in the pursuant to order passed earlier, the records of the tribunal is received, requires examination. Accordingly, issue notice, returnable on so and so, release the matter on so and so. In the admission column, awaiting records of the awaiting records as called for. Same day. Yes, item 3. Your voice is not clear. So put on your speaker.
Impugn judgment is page number 30, madam.
page?
Page 30, Malaysian relevant portion is para 7. Malaysian proceeding para 7, page number 31. Proceeding Onil Muni Das in his written statement stated that he is a bona fide citizen of India, born and brought up at village Pohara Pakar, Moza, Bomanipur, PS Barpeta, district Barpeta. In the written statement, Proceeding stated that his father's name is Tinumuni Das. Tinuram Muni Das, inhabitant of village Pohara Pakar, Moza, Bhavanipur, PS Barpeta, district Barpeta, and his name appeared in the voter list of 1960. Under the then 48 number Bhavanipur LSA by house number 4, serial number 8 at village Pohara Patar. Proceeding stated that his elder brother, namely Kishore Lal Moni Das, alias Kishore Moni Das, name has been enrolled in the NRC details in 1951. Right, house number 5, serial number in house number 2, legacy data, code number Iman at village Pohara Patar, and his name has been enrolled in the voter list of 1970 under the then 48 number Bhavanipur LIC by part number 147, house number 1, within bracket 1, serial number 5 at village Pohara Pathar. Proceeding stated that his name has been enrolled in the voter list of 1985 under the 41 number Bhavanipur LIC at village Pohara Pathar. And in the same voter list, his elder brother's name has been enrolled. Proceeding stated that his father's name has been enrolled in the voter list of 1989 under 41 number Bhavanipur LIC by number part number 1.
Is there any voter list of you and your projected brother together?
His brother name, his name appeared in the voter list of 1989. So he submitted the document. The honorable tribunal did not believe him. That's why he declared foreigner.
No, we are asking that whether there is any voter list of you and your elder brother together. No. Then how have you linked yourself to him?
He has no difference.
The 1970 voter list, only the name of his brother appears.
Brother system. As per his version, his father is expired on 1960.
Father expired when?
1960.
1960. But there is a lack of your link with your projected brother or father. Yes. There's no link.
His father name is recorded in NRC detail in 1951, case number 17. There some discrepancies is the legacy of India is not correctly exhibited. In the voter list of 1970, his brother name is recorded. His father name is not recorded. Petitioner name is recorded in the year 1989.
What is this, year of birth? Year of birth? Mention. Born. It's not mentioned. It's not.
His date of birth is not given. He is only, he brought up Pahara Pata under Moga Bhavanipur, PSN, Gorpeta of Assam. His date of birth is not given. And there also their case as a reference has been in a case under IMDP reference case number 5435. IMDP reference. Thereafter it was changed by the case number 215. Case number 215 of 2016.
Yes, Mr. Payan.
Fine. Thank you.
My lord, though in WS, my lord, the petitioner pleaded his father had a voter list, but that has not been exhibited. There are only 4 exhibited documents, my lord. Number 1, the voter list of 1970 of his projected brother. Then voter list of 1989 of the petitioner himself. Then an affidavit correcting the name and Gauhati certificate. So first of all, my lord, the petitioner's existence prior to 1970 is not there. Secondly, to bring lineage from his father, my lord, his father's existence is also not there prior to 1970. If we accept the age of the petitioner as per the voter list of 1989, he was eligible to be cast vote in the year 1970 itself. In 1970, he was 21 years. So, my submission, my lord, there is, he has brought a document of his brother, convicted brother, but there is no document to show that he is the brother, and there is no common voter list or any document to link the petitioner along with his brother also. In fact, the brother's lineage cannot be drawn. Brother cannot, because one person may come prior to 1971. One person may come after 71. That aspect is also to be seen. Possibly.
Number 12.
Third, Mr. R. Begum, Learned Counsel for the petitioner, and so for the respondents. Next one. By filing this petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has sealed the opinion dated case 30. 13/12/2018, passed by so and so, in 50 case number so and so, IMDT reference number so and so, by which he was declared to be a foreigner for 25 to 1973. This petition was filed on 5/11/2019, and the record of the travel was called for by order dated 5/5/2020. To stop, as the records have received from you consider both sides, the matter has been heard. Next paragraph. The uh, on receipt of notice of the proceedings, the petitioner appeared and filed his written statement, among others, stating that he was born and brought up at village Khara, Khara, Pathar, Moza Bhawanipur in the district of Borpeta, under PS Borpeta and PS and district Borpeta. Full stop. He claimed that the name of his father is Tinu Ramdas, Tinu Randas, alias Tinu Monidas, alias Tinu Ram Monidas, inhabitant of the same locality, whose name appeared in the voter list of 1960. In the voter list of 1960 from village Khara Pathar, Khara Pathar, under 48 Bhawanipur LAC, and his name also appeared in the NRC details of 1951. Was a resident of the same village. But actually, you can add together this what is it for 1960 and 1970. Born and brought up, this is born and brought up, born and brought up. If you favor out of this. Give it to the
No, yes, 1989. Manasi, when the impute judgment was passed, the petitioner was detained. When we have filed this petition, that time he was in custody, but we have not granted any bail from the honorable court magistrate. Now, I don't know the present status. Bail is not granted. I think it is
But detained in 2019.
in 2018. When we have filed this reference, this petition, that time he is in custody.
So it was further stated that in the voters list of 1985, the name of the petitioner as well as his brother appeared and in village Kora Pathar under 41 number Bhawanipur LSD. The name of the petitioner appeared in the electoral roll of 1997, it was marked as doubtful voter. Which remained in the voters list of 1997 to 1996. The petitioner relied on the certificate issued by the Gauhati of Gora Pathar. Accordingly, it was submitted that the petitioner was not a foreigner but an Indian citizen. Next paragraph. In support of his evidence, the petitioner had examined himself as DW1 and one Priyanath, the Gauhati of Gora Pathar and Gora Gaon, examined as DW2. The petitioner had reiterated his statements made in the written statement in his evidence on affidavit. He had exhibited the following documents. Voter list of 1960, we can take it Exhibit A, bearing the name of his projected father, namely Tinu Ram Das. Nothing is wrong in this matter. In your evidence, you say that Exhibit A is the voter list of 1960.
1966, other name is recorded. What is your page number? 12.
Nine.
Like,
60 to say that. This is 60 to 5. No.
Page number 12, my page number.
Well,
And this is 12. Next page. Serial number 8 is father name. Tinuram Das, father name.
no, this is not an exhibited document. Foreign document. No, and as per the said evidence on exhibit, the petitioner had exhibited the following document. Voter list of 1960, in bracket exhibit A. Certified copy of voter list of 1970, within bracket exhibit B. Certified copy of voter list of 1989, within bracket exhibit C. Name correction affidavit, within bracket exhibit D. Certificate of the Kangura of Kora Pathar, within bracket exhibit E. How found? On the perusal of the travelers records, exhibit A is the electoral roll of photocopy of the certified copy of the electoral roll of 1970. Photocopy of the electoral roll of 1989. Photocopy of certified copy of electoral roll of 1989. In fact, exhibit D, contains the name of the voter is Anil Chandra Das, son of Edu Ram, aged 40 years. The affidavit shown before the notary public on 31/5/2017 was marked as exhibit C. The certificate of the Kampura in Hindi comma to go to this is exhibit D and the signature of the Kampura is exhibit D by 1, D within bracket 1, small Roman 1. For his cross-examination, the petitioner had stated that his name was Andrew Mani Das. And name of the father was Tenu Ram Das. T-E-N-U. This one, he had stated that he was born in Kohara Pathar. He does not remember, he did not remember when his father had died. This one, he had stated that he has a brother, his name is Kishore. Kishore Lal Muni Das, who was expired. He does not remember, he did not remember when his mother had expired. Kohara Pathar. Kohara Pathar. He had further stated that he does not remember when his father had expired. He stated that in Kohara there is London house in the name of his father. And at night that it was he had given false evidence. Next paragraph. The petitioner had examined one clear act of the Gaubra of Kohara Pathar and Kohara village. First one, he had stated in his examination in chief that exhibit D was the certificate issued by him, where D by within bracket Roman 1 was his signature. He had stated that he knows the petitioner and other family members. This one, he had stated that the civil party had decided other family were known to him and he was presently residing at Kohara Pathar. Yes. He has also stated that the name of Anil Mani Das and his family appeared in the voters list, but he does not remember in which year their names appeared. That's fine. In his cross-examination, the petitioner, the DW had stated that he was the governor since 1984. And the name of the father of the petitioner was Tenu, T-A-N-U. And his father expired in the year 1960. And the petitioner was a resident of was under his charge of It stated that the petitioner was a resident of his village. He maintains the register of certificate issued by him, and he was issuing certificate for last 10 years. He was the governor of Korba Pathal and Korba Gaon. And in these two villages, there are about 7,000 residents. And he had stated that he does not maintain any register. He had denied the assertion that he had given a false evidence. Next paragraph. The learned tribunal on appreciating the materials available on record refer to the stand taken in the written statement and the evidence of the evidence available on record. And it was held that on a scrutiny of the written statement, it was evident that the petitioner had not disclosed basic material facts which were within his specific knowledge. First, although he had claimed citizenship by birth, but petitioner did not mention where he was born. He remained silent regarding his mother, grandmother, grandfather, and children of his grandfather. Accordingly, it was observed that when person's citizenship is being questioned by the state, one has to disclose all material facts which are within the special knowledge of the petitioner to establish his citizenship. and required to prove by adducing cogent and reliable evidence. Stop. Referring to Exhibit A, which is the electoral roll of 1970, Learned Tribunal observed that the petitioner had projected his brother's name from the electoral roll of 1970, but he has not submitted any other voter list of his brother after 1970. And accordingly, Exhibit A was held to be not reliable. So, referring to the electoral rule of 1989 within bracket Exhibit B, the tribunal observed that the age of the petitioner was 40. And accordingly, it was held that the petitioner was eligible to vote prior to 1989. But he has not disclosed the reasons why he did not exercise why his name did not appear in any voting prior to that. The voters of 1997 and 2010 within bracket. Once you take it, let's take it out. So that the learned tribunal took note of annexure A, to the A, B, and C to the which A, B, and C. And accordingly, it was held that those were photocopies and could not be relied upon. So Exhibit A and Exhibit B were the voters list containing single names. And therefore, the learned tribunal opined that no conclusive had held that, had observed that there was no conclusive opinion could be drawn as to whether the said voter list actually belonged to the brother of the petitioner or not. Where is the voter list of 1989? Nineteen eighty was not exhibited.
Page number 20 only. Type to be 20, something to be 21.
Because of voter list, it is high. It is দুটা নাম আছে ইয়াতে এটা আছে এইটো ডকুমেণ্ট নহয় না এইটো বেলেগ বস্তু আছে ওটো এইটো না মানে মিছমিছৰ কাৰণে অলপ whether the same belong to the whether the petitioner or not. referring to the deposition of the Gauhati within bracket DW2, he had referred, he had, they said with this referred to his certificate within bracket exhibit D, and his signature thereon within bracket exhibit D within bracket 1, Roman 1. Yes, 34. Each cost examination disclose that certificate has been issued on the basis of that proceeding. This is never. Look at the also, you can call me. Suffice to mention that the evidence of the DW2 was not found trustworthy, as he had issued the certificate of the as he was as the petitioner was of his village. Accordingly, it was held that the petitioner had failed to discharge his burden to prove that prove under section 9 of the Foreigners Act that he is a citizen of India, not a foreigner. Resultantly, consequently, the petitioner was declared to be a foreigner for 25 till 1971. Next, the knowledge comes for the comes for the petitioner admitted that finding of the traveler was not sustainable, as the traveler had discarded the evidence to the effect that the Arjun Manga, whose name appeared in the voter list of 1989 within bracket exhibit B, was his brother. It was submitted that the photocopy of the certified copy, a photocopy of the electoral roll of 1989 disclosed the name of the petitioner along with his projected brother. But the Laureate Tribunal took a hyper-technical view and rejected the claim of the petitioner as the voters list were photocopies. It's submitted that the name of the petitioner appeared with his brother in the electoral roll of 1997, 2005, and 2008. And it could be corroborated with the entries made in the legacy data of the father of the petitioner. Accordingly, it's submitted that there was the link between the petitioner and his father and the elder brother was established. Next, the only counsel for the petitioner has submitted that in paragraph 15 of the writ petition, it was stated that though the impugned opinion of 13/12/2018 was assailed, but by then the petitioner was detained in jail awaiting deportation. So it is submitted that she has no instructions as to the present whereabouts of the petitioner. Next paragraph. The Standing Council for the Border and Rescue Matters has made its submission in support of the impugned opinion. Next paragraph. On the perusal of the tribunal's records, it may be pertinent to mention that the learned tribunal had incorrectly appreciated the statement made by the petitioner in his cross-examination. Mr. However, might be stated that the discrepancy in appreciation of the cross-examination is not material which otherwise dislodge the petitioner from the status which has arisen, which arose out of the opinion impugned in this petition. Full stop. The incorrect reading of the cross-examination is to the effect that the DW2 had not stated that Exhibit D was issued on the basis of the petitioner being his neighbor. However, it has been stated in the cross-examination that the petitioner was his resident, his resident inverted commas, it appears to be an error, and it could have been and ought to have been the co-villager of his co-villager, for which the certificate was issued. the statement of the DW2 that he maintains a register of certificate copy, which was wrongly appreciated that he does not maintain any register. First of all, the said discrepancy from the considered opinion of the court would not be of any effect and would not render the opinion as perverse. Next part. The fact remains that the petitioner was aged, the petitioner disclosed his age as 63 years in his written statement filed on 1/10/2016. And therefore he was born in the year 1953. And he was eligible to cast his vote after the year 1974. Gustav Hauer, his name got enrolled in the electoral roll. In the year 1989. His age is 40 years. Gustav, there is no document regarding the existence of Kishore Mani Das, whose name appears in the electoral roll of 1970 within bracket Exhibit A. Who is mentioned as son of Tenu Mani Das, aged 28 years. So, though the petitioner stated in the written statement that his name along with the name of his brother appeared in the electoral roll of 1985, along with his brother, but they said that total list was not exhibited. So the Gauhati certificate within bracket exhibit D, exhibited by DW2, is found to be not admissible in evidence because of use of the state emblem, which the Gauhati is not authorized to use. Therefore, comma, the mere certificate from the Gauhati would not be enough to prove that the petitioner was a citizen of India or that his parents or elder brother was in India before the cut-off date of 25/3/1971. In view of the fact that the petitioner has not been able to link himself with Kishore Mani Das, who was projected as his elder brother and whose name appears in the electoral roll of 1970 within bracket exhibit A. Next paragraph, resulting the comma. The court does not find any conformity with the imperial opinion dated page 30. Imperial opinion expensive, part basement expensive. Next paragraph. Accordingly, this judgment fails and the same is dismissed. What's pending? The consequences of the opinion, said opinion shall follow. Next paragraph. The registrar shall send back the record, shall return the record to the tribunal along with a copy of the order to be made a part of record by the said tribunal. Next paragraph. The balance standing for the border and electoral matters and also transmit a download copy of this order to the concerned authorities.
For motion item 4.
Read the Lordship. Lordship, an expiring order, Lordship. Indian order is at page number 24, Lordship.
24.
Thank you, sir. Lordship, Lordship. Yes, Lordship, in this case, notice was received by the Gaubura of number 3 and 4 Boruachar, Lordship. Thereafter, Lordship, Gaubura demanded 20,000 money from the petitioner, Lordship. And Lordship, the petitioner was very poor. She refused to pay that money. Then Lordship, the Gaubura threatened the petitioner that threatened petitioner and took some impression from the petitioner forcefully. Thereafter, Lordship, the petitioner appeared before the tribunal and filed her WS. And Lordship, the petitioner fully depended upon his learned counsel, Lordship. And the learned counsel, Lordship, said the petitioner that
The petitioner lordship that no need to worry about this matter lordship. Then lordship, the petitioner was visited lordship. Then she went to Kerala lordship from livelihood lordship. I have annexed the order sheet also lordship. Then lordship, the ex parte order was passed on 8/6/2015 lordship. And the petitioner was totally unaware about the ex parte order lordship. Thereafter, Lordship, and that was on her knowledge on 5/8/2019 Lordship. The Learned Council did not inform the petitioner Lordship, and when the petitioner came to his native village for NRC hearing, and from the NSK center, she came to know that she was declared foreigner lordship. Thereafter, the petitioner immediately applied the certified copy and came to this.
Do you believe in that?
Lordship.
Do you believe in that story?
Lordship, it's true lordship.
The Tambura demanded 20,000 for
You did not lodge an FIR.
giving the notice, for giving the notice. Tambura demanded the money for
From the petitioner lordship.
giving the notice, for
Lordship.
showing her the notice.
Yes, lordship.
How did you
Yes.
file your written statement?
Lordship, petitioner has filed the written statement. I have not annexed lordship.
No, but how did you file it if you did not know about the notice? The Gauhati demanded money. But you file your written statement.
Then she appeared lordship. Then she appeared and filed her WS lordship.
Therefore, after that, why did you put default? The Gauhati was not giving dharna in the road.
Lordship.
Then there is one bad habit I can't shake off. See this. Is not functionally in state of Kerala.
Not Kerala lordship. She came to.
But look at your statement in paragraph 7, page 7. He because he came to his native village from Kerala for NRC hearing, and from NRC center he came to know. So therefore, you got notice of the of that application, the NRC hearing. But by that time, in 2015, you already were declared to be a foreigner. So you would not never received what you call the notice of hearing in an NRC.
She was declared in 2015, yes, lordship, but this was on her knowledge on 2019
Please
lordship.
tell us, if you are declared foreigner in 2015, will you get a notice of hearing in 2019? Because once you are declared to be a foreigner, then NRC stops for you.
Yes, lordship, but she was totally unaware
That's
No,
what
but
she
you
came and
You
when-
went to a hearing.
went to the NSK center.
That's a hearing body process. Hearing how?
Won't be a hearing because by the time the opinion had already come. But probably she went to the NRC center and there she came to know that she was
Yes.
declared for it. So according to your instruction and what you were pleading, she received the notice for NRC hearing.
No notice, no notice,
NRC hearing, no.
no notice,
After
but she
declaration,
came,
as my
yeah.
brother said,
she came and
declaration,
went to the
not any
NSK center.
NRC
Page 7,
They
not
said
5.
she came, yes, to his native
After
village. from-
declaration as for by FP, there only any NRC proceeding. It's no longer relevant.
From Kerala for NRC hearing.
Yes.
And from the NSK center, she came to know that she is declared for it.
But Mr. Sharma still falls within the third category of that Savitri Day. And we will be able to demonstrate that we asked you that query, whether you believe in that story. You said yes. See the flat page.
Acha.
That's this is flat page. Yes. You've seen this. This is Gauhati certificate in 2012. So not to ask, not to say about the demand of money, he had in 2012 only given you the certificate. After that, is it possible for him to demand and for you to take the plea? He gave you the support.
Are there any documents, leakage documents?
But Mr. Sharma, still, although the presentation of the case is not up to the mark. But come to page 15, we think this matter should be remanded back on the third ground.
Aleha Khatun. Aleha Khatun.
Her name appears
1966.
in 1966. What is this? Khalu is the husband. So shall the record again?
In the opinions, is mentioned this Aleha Khatun in the opinion. It's an
Lordship.
LIS, it's sorry.
LIS.
The opinions is record as LIS.
Alejo Khatun LIS Ahela.
1966 photos. Sure. Next. Purportedly. It mentions her name is Aleha. She must be an aged person, then she's an elderly person. How old is she?
Lordship.
Because if she's appeared in 1966
Elderly
as
person.
a voter. Present age of
Present it should be 74. Lordship.
74.
No, but you still don't get the benefit. Here, you see page 33 and 35. For the bus. In 2012, she got a notice. She appeared, filed a written statement. Thereafter, she defaulted. And in 2014, she again got a notice that if you don't appear, you will be declared foreign ex parte. That is 33 and 35. So for the second time also notice was served, but she did not appear. Wait to her. Mr. Sharma, show that page 33 and 35 to her.
Mentioned also in the impugn or opinion that a specific ex parte notice was also given. But,
33 and 35. This page 33, 34 was before you filed your written statement in 2012. Second notice is of 2014, served to you on the ground that you will be declared ex parte. This notice was also served.
Lordship kindly remand back and Lordship for face adjudication. Petitioner is very elderly person and otherwise these are illiterate person, Lordship.
There is a third flaw in your presentation.
Lordship.
There is a third flaw in your presentation. You see, as per the voter list of 1966, he was 21 years of age. We are seeing, looking at the TCR. Alia Khatun, wife of Hello Sheikh, which is there in your document also.
Mhm.
Page 15. Her age is 21 years.
That's it.
Therefore, she will be born in 1945. You say that in 2012, after filing of the written statement, she went to Kerala for work. In 2012, she would be 67 years. So what sort of job a 67-year-old lady would be doing? We fail to understand.
For daily wage labor, that lordship.
We understand, but what labor can a 67-year-old lady do?
ठीक है.
She'd be old for manual work,
That's it.
but he has to operate an industry or to have shops and establishments. Yes, a aged man can do. He'll be keeping workers and then doing it. But to do manual labor at the age of 67 is something we can't comprehend. This is the third law. Is received, comma, received. Next, accordingly, as the late petition is of the year 2019, the matter was heard at the motion stage. Mr. Mrs. conclude, order reserved.
Like,
Item 5 for motion.
Please, your lordship, respond. My lord, this matter will take some other day, my lord, because today I don't have brief, my lord. Or your lordship may take it for admission here any date, next week in any date, my lord. Admission, not for motion. Motion, my lord. Examination is received, command requires examination, accordingly issue notice returnable on so and so. You have copies? You have copies?
Yes.
Without requiring any steps to be taken, next list in the admission column on so and so. 60. 67. Over.
Item 6.
Please, your lordship. Lordship, the impugn order here is on page 65, your lordship. starts from page 65, Your Lordship.
Which page is that? Exhibit 2?
Yes, Lordship, Exhibit 2. Your Lordship will find Exhibit 2 on page 30. But it starts from 31, the type copy. Original starts from 33. Your Lordship, it is a copy, Your Lordship, copy of the order of my elder brother who has been declared as an Indian, Your Lordship. And Your Lordship, nothing has been discussed regarding this, Your Lordship.
That's what we noticed.
Anwar Hussain is me, Your Lordship, the proceeding. Sukul Hussain is my elder brother. Sukul Hussain, page 33, who has been declared as an Indian.
Mr. Sharma, this has not been discussed.
It has been exhibited, Your Lordship. It has been exhibited and marked as Exhibit 2 in page 66.
Exhibited, but we did not find it. That's why only one question we asked.
And Your Lordship, another thing, Your Lordship, even Exhibit 1 has not been properly discussed, Your Lordship. Your Lordship, there are certain reports that has been sent to the Foreigners Tribunal regarding the authenticity of the certificate, Your Lordship, but that has not been discussed in the order.
No, that will not be very fatal.
Lordship.
Exhibit 1 is the school certificate.
Yes, Your Lordship.
The school certificate, the headmaster did not come and depose.
Your Lordship, headmaster has sent a report, Your Lordship.
Came and deposed.
Yes, Your Lordship. Your Lordship will find, I have annexed it, Your Lordship. And it is also in the LCR, Your Lordship. I have controlled it. Page 29, it starts from page 25, Your Lordship. There are two reports, one by the headmaster, one by the SEBA, Your Lordship, Secondary Education Board of Assam.
No. Something is wrong then. Yeah, you have the record with you. Just check it up. This DW, he says that the headmaster was examined.
Lordship, no, Your Lordship, a report has been sent by the police. Your Lordship, to the report submission, Your Lordship, Perus 25, Your Lordship, that there was a case, Your Lordship, that has been instituted, that a fire has taken place, Your Lordship. Therefore, some documents has been, Your Lordship, destroyed, Your Lordship. The HSLC examination statement and mark register from 1953 to 2007. That is a police report that has been sent, Your Lordship. And thereafter, there is another, Your Lordship, which starts from page 29. It is sent by Suranjana Senapati, ACS Secretary, Board of Secondary Education, Assam, to the members, Foreigners Tribunal for Tejpur and Gauhati. He says, inviting a reference to the above, I have the honor to state that the photocopy of the admit card given for verification is verified with the office record and found as follows. Roll number so and so. Candidate's name, Muhammad Anwar Hussain. Father's name, late Nabi Hussain. Date of birth, 27/9/76. So it has been verified by the Secondary Education Board of Assam through a letter that has been sent to the Foreigners Tribunal. So that all those things has not been brought into in the order.
It was not discussed lordship on that term. That was brother's opinion, he pleaded also lordship. But
There's something else we require to see. That's it, nice. Itu?
Itu dia.
only pleading is there, lordship, but there is not a single document at all, lordship. Only pleadings is there that his brother was declared as an Indian citizen, but lordship, there is nothing in the record of that Tukurali his brother, lordship. Apart from that, lordship, Nobi Hussain, projected father of the proceeding and grandfather, there is a lack of link between them.
Well, amazing.
Your Lordship, he has been cross-examined. Your Lordship. Yes, sir.
There have been some reason. If I had missed it for some reason, then there must be a reason. In this case, what had happened was that written statement was filed.
Lordship.
He came and gave evidence, did not stand up for cross-examination. Then the DW2 was examined. After that, he files a petition on 9/7/18. When his cross is incomplete, he files a petition to amend the plaint and the written statement as the evidence. That was allowed by, and 10/8/18, written statement and evidence was filed. After that, he did not come for his examination.
So the amended litigant.
After the amendment, the court gives an order on 10/8. Then after 6/9/18, then 4/10/18,
He has not himself appeared. Possible.
22/10/18. Then on 22/10/18, the petitioner was put to notice that if he does not appear for cross-examination, the matter would be heard ex parte. After that, on 2/11/18, again he is absent. Again, he is warned of ex parte. Then 15/11/18. He is absent again. 1/7/19, court reserves for order. And on 25/7/19, declared to be a foreigner. So after amendment, if you don't stand for the cross-examination, everything falls, even your brother's opinion, that goes.
Your Lordship, Your Lordship, the evidence in chief, Your Lordship. Lordship will say that from page, actually in this case, Your Lordship, the written statements and evidence in chief, that's filed together, Your Lordship. As per the order, Your Lordship, and if Your Lordship peruse page 50. '57, '58, '59, Your Lordship. Actually, Your Lordship, these documents, Your Lordship, the school certificate, the order copy were filed along with the evidence on in 31/5/2016, Your Lordship.
What happens if a written statement is amended?
Your Lordship, in that, what I'm trying to, Your Lordship, say is, Your Lordship, in the earlier written statement only, Your Lordship, which was filed in 31/5/2016, Your Lordship, these 4 documents were exhibited. Thereafter, he appeared for cross-examination on 6/1/2017, Your Lordship.
But he had a brilliant idea of having his written statement amended. The amendment of written statement as well as the evidence was allowed.
Additionally,
Though we don't approve of it, it should have been additional evidence because an affidavit cannot be amended.
Lordship.
But written statement was amended. There's a order sheet which says that amended written statement has been filed.
it created some complication actually, because if it was additional evidence and he did not appear, then certainly only the additional evidence could have been, kind of washed off. But here actually, though it was not strictly in terms of proceeding, the additional, the evidence got replaced. Unless we treat it as additional evidence, then what happens to the earlier crops? You know,
Yes,
crops examined with regard to the earlier evidence. Right, but the evidence cannot be, it's only written statement can be attached.
Yes, but
It's not a link.
Yeah.
It's not filed, it is not filed.
not, yes,
We did not file.
yes, your lordship,
I-
that's I was supposed to say, your lordship, if any additional written statement or evidence was filed, I was not served with a copy by the prosecutor, neither has.
No,
seen
it is
in
not
the
there.
record.
This not I failed to read. It's error.
Not mandatory.
Actually, your lordship,
I stand
the
corrected.
petitioner stays in Arunachal Pradesh, your lordship. He is indulged in some business there.
It was proposed to be filed, but not filed.
Not filed.
So
My lord, item 38, there is an order that after receiving TCR, bail may be considered. So, my lord, TCR has come. I am in problem because police is behind me. It may kindly be taken.
We will try to take it up, but because we have to rise early today. We'll try to. We'll be rising by 3:50 today. Yes, item 6. Moving on. Mr. Sharma, then we are remanding it only for that exhibit 3. Sorry, that earlier only on that ground. Sorry, exhibit 2. Heard Mr. I. Hussain, Learned Counsel for the petitioner, also heard so-and-so for the respondents. Next para. Pursuant to order passed earlier, the records of the tribunal is received, received, full stop. Accordingly, with consent of both sides, the matter has been heard at the in the motion stage. Next para. By filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 25/7/2019, page 65, passed by so-and-so in so-and-so, by which he was declared to be a foreigner post 25 to 1971 stream. Next para. In view of the order of remand which the court proposes to pass, the readings and the evidence of the readings on record of the learned tribunal has not been extensively referred to. Next para. It would suffice to mention that pursuant to service of notice, the petitioner appeared and contested the case by filing his written statement as well as evidence on affidavit and he was cross-examined on his evidence tendered. To stop. In support of his defense, the petitioner has exhibited school certificate as exhibit 1, semicolon. Opinion dated page 33, dated 28/9/2007. Passed by so-and-so in FT case number so-and-so. Here is FT Roman 2. No? Just check it up. Passed by so-and-so and so-and-so. With the petitioner projects is of his brother who was declared not a foreigner. Semicolon. Certified copy of voter list of 1971 within as exhibit 3. Earlier was exhibit 2, that or opinion. And certified copy of voter list of 1966 as exhibit 4. Next para. it may be stated that though the learned tribunal had permitted the petitioner to amend the written statement and to file evidence, but it appears that the petitioner has forgone their state liberty and he did not turn up for his cross-examination, and therefore the cross-examination was therefore there was no cross-examination of the petitioner as DW1, and therefore after putting the petitioner to notice that if he fails to appear for cross-examination, ex parte opinion would be passed, despite order dated 22/10/2018, 2/11/2018, and 15/11/2018, while the petitioner did not appear for his cross-examination. So accordingly, the matter is reserved for opinion by order dated 1/7/2019, and by the interim opinion dated 25/7/2019, declared to be a foreigner. Next, it is noticed from the said opinion, said interim opinion, that the learned tribunal did not make any discussion in the interim opinion regarding the said Exhibit 2, the opinion dated 28/9/2007, referred above. Next paragraph. Accordingly, as the orders by which the orders of the learned tribunal by which the matter was heard without the recording of the further cross-examination is not under challenge, the court is inclined to remand the matter before the said learned tribunal for passing of fresh opinion after considering the evidence, including the evidence of DW1 and DW1, 2, and 3. There are 3 witnesses.
Your Lordship,
There are 2 only.
Your Lordship, DW, Your Lordship, one from the election office, he is Marches
He is
DW.
DW, but he should be 2, I think. Only 2 witnesses are on record.
Yes, Your Lordship.
DW1 and just before that you say, it is also noticed from the tribunal's record that the petitioner had examined himself as DW1 and he had examined another DW, namely Manoj Dahal, DAHL, assistant election office. Sorry, junior assistant election officer from Vishwanath Sadini. So how in the form of deposition, it is seen that the learned tribunal has recorded the DW2 as DW3 on 25/10/2016. Then all that DW1 and his cross-examination and DW2 and pass a fresh opinion by considering the readings and the evidence of record. Next para, in order to facilitate the learned tribunal to pass a fresh opinion, the impugned opinion dated 25/7/2019, page 65 is hereby set aside on the ground of perversity for not considering Exhibit 2. Next para. The petitioner, duly represented by his learned counsel, is directed to appear before the learned member, foreigners tribunal within bracket 2, bracket close stage 4. No, it will be 4. Fourth. Learned member, foreigners tribunal within bracket 4. Oh, there is no bracket. Tribunal 4, stage 4 at Gopur. Within the outer time limit of 28/9/2026. So on the said date, the petitioner, by producing a certified copy of this order, or shall await for further orders to be passed by the said learned tribunal. Next para. The registry shall expeditiously return back the records of the learned tribunal along with a copy of the order to be made a part of the record by the said learned tribunal. Next para. The learned standing counsel for the border and nifty matters shall also transmit the download copy of this order to the competent authorities for the record.
Lordship, I am also appearing in item number 8. So Lordship, but the petitioner is not in contact with me since 2019. The last time he said that he wants to take the benefit of Citizenship Amendment Act. So if I can clarify that and your Lordship come back, your Lordship, if your Lordship.
Both sides are represented. On the prayer made by and counsel to the petitioner, attachment is drawn today.
In the meantime, you can post it for admission. In the meantime, you take your instruction, Lordship.
Next, pursuant to order passed earlier, the records of the tribunal is received from which requires consideration. Accordingly, court is inclined to issue notice returnable on so requiring any steps to be taken. Next, list in the admission column on so
Right.
Item 9.
This is Lordship. Lordship, this letter may kindly fix in the admission column, Lordship.
Which is represented, pursuant to order passed earlier, the recording of traveling receipt, which requires consideration. The court is inclined to issue notice, returnable on so and so, based in the admission column on so and so.
Post place.
Item 10.
May I please, Lordship, kindly this matter be taken up after some time.
will be called sometime later. The one file is not available.
One of the files is looking for this thing. One of the.
That's not very material, but the file is not there available right now. Just wait for some time.
Item 13.
Transferred, Mr. Sharma. But that decision has already been rendered, settling the position.
What is the full domain decision?
Yes, it is reflected in the last order, 2022 last description. Janglu only, is it Janglu?
No, in Janglu there was a difference of opinion and referred to a larger bench, third bench, as 3-judge bench.
They come, but not permitted. Not name, case name are for.
Shariful Islam. Full bench we have not been able to locate. Full bench decision we have not been able to locate. No, we have not been able to locate the full bench. Full bench we have not been able to locate. Mokibor. What will be the spelling? What will be the spelling? Mokibur. No.
On the plea of the petitioner of no order, member of the conflict of interest. We can still out the only asset.
Oh, yes, we got it. Makibur Rahman. 3 GLT page 7. 2024 3 GLT page 7. Makibur, Makibur.
Except from to exceptional circumstances.
Correct view. Okay. Listen, none appears on call for the petitioner. How all the respondents are represented. Next para. The Mr. G. Sharma, and standing counsel for the water and FT matters, has submitted that the present writ petition has been filed for transfer of the proceeding of case number FT oblique S VR oblique 365 oblique 12 from the Foreigners Tribunal Jorhat to the native district of the petitioner. To stop. As per the statement made in paragraph 1 of the writ petition, comma, the petitioner is a resident of South Salmara district. Next paragraph. No, not next paragraph, same. Full stop. It is submitted that in the said context, this court had deferred the matter, comma, awaiting outcome of decision of this court in the case of Jonglu, Jonglu Ali alias Jonglu, Janglu Ali versus Union of India and others, comma, WPC 7309/2019. So it is submitted that the said case was already decided by this court
Jonglu Ali was segregated from this branch of repetition lordship.
No, that's okay. We are not in that. Don't give it to us sometime. A date, disposal date, but decided on so and so. By referring the matter to the larger bench, and accordingly, this court in the case of Makibur, Makibur, Makibur Rahman versus Union of India and others, 2024 within bracket 3, bracket close, GLT 7, had answered the reference by holding that the decision of this court in the case of Shariful Islam, Shariful Islam, alias Soriful, Soriful Islam, and another versus Union of India and others, within bracket 2019, bracket close 8 GLR 322, requires no interference. Accordingly, it is submitted that the full bench of this court had decided in the negative that proceeding before a foreigners tribunal will be transferred, save and except two exceptional circumstances mentioned therein. Next, in that view of the matter, as the petitioner has remained unrepresented on the matters adjourned today, next, it is made clear that if the petitioner remains absent on the next date of listing, the court would make an attempt to dispose of the matter on the basis of the full bench decision of this court. Next, list on your date after 2 weeks.
Motion item 11 with item 12.
both sides are represented in view of order dated 15/7/2026, passed in WBC 8921 of 2019 and order dated 13/7/2026, passed in WBC 9092 of 2019. This is the matter in the admission column on 25th January. What's his तारीख?
Hmm.
27/8/2026.
There'll be next meeting.
देखिए तो 31st August.
21st August.
31. 31.
31.
Item 14.
May I please worships. In this case, my lord, the impute order appears, my lord, 27, my lord. Because by that order, my lord, my evidence of the, my lord, last model has been closed and think the matter for argument, my lord. On, my lord, on the very, my lord, second day, my lord, I have already taken steps for the, my lord, last model, my lord, for issuing summon. And according to summon has also been received by the last model. The very second date, my lord, my evidence has been closed. Even after, my lord, I have signed a petition for adjournment, my lord. Kindly see at page, my lord, page 25, my lord. That is when my petition on 2/7/2026, my lord. And as per court's order, my lord, I have filed the
Record आना चाहिए इस ईयर आना चाहिए
and we have to look at page, my lord, 25, my lord. As per, my lord, order page 23, my lord, order dated, my lord, 17/6/2026, my lord. On first occasion, my lord, Ratmondal could not appear, my lord, on first occasion, my lord. And my lord, on second occasion, my lord, on 2/7/26. On that date also, my lord, Ratmondal could not appear, and I have filed the petition, my lord, for adjourn, for fixing another date, my lord, for examination of the Ratmondal, my lord. And on that very day, my lord, yes, my lord. Thus, my lord, I'm sure, my lord. Yes, my lord. There's a Ratmondal's evidence very material, my lord. Otherwise, my lord, we have already, my lord, examined, my lord, two witnesses, my lord.
He was the third.
Yes, already cross-examined, my lord. And proceeding, my lord, started in the year of 2025 only, my lord.
Proceedings are required to be closed within 90 days.
My afford an opportunity, my lord, so that, my lord,
Where's the opinion? Which?
नहीं तो close कोई नहीं यहीं से चैलेंज हो गया
order, my lord,
close कोई नहीं करना है यहीं से
and page 27, my lord. Page 27, my lord. 27.
But you have availed a lot of adjournment on the ground of Lat Mandal.
Yes.
So this was rightly done. If there is not appearing in 1 or 2 dates, you should have asked the tribunal to issue summons. That is what is said in this Muslim Mandal case. The Lat Mandal would have been DW3. Correct. For him, we are taking adjournment on 1, 2.
Almost 5 months, Lord.
3, 4.
Law says that proceeding has to be completed within 60 days, Lord.
5, 6.
Trial.
Yes, because last month, this is the second date, madam.
No.
In
The case was fixed for DW3 by order dated 11/2/2026. So from 4/3 you are taking an adjournment. That will be 1,
Yes, sir.
2, 3, 4, 5.
Fifth date it was. On the fifth date it was rejected.
February
Uh,
to July.
Tribunal was also left with very little options because of the 60 days.
Yes, Lord.
That has to be complied.
Yes.
Fair level.
And the tribunal is regularly saying that you will take steps. You have not stated that you have taken steps.
It's taken one steps, madam, as per, Case 20, my lord. Case 20 order, my lord, is for saying to close the evidence of DW2, my lord. DW3, evidence of DW3 has been closed. And fix the case for Lakmondal's witness, my lord. For the first time, my lord, the case is fixed on, my lord,
4/3.
4/3 we have already told you. This is what you have already said.
yes,
After 4/3 there is 4 dates.
first, my lord, first date for examination of Lakmondal is date, my lord, 17/6, my lord. This is the first date, my lord.
No. It is 4/3, page 21.
Then on the fifth day, it was rejected.
Fifth date was closed.
DW3, my lord. DW3 has been closed, my lord.
On 5th day.
And check on the fifth day, 4/3/2026. And 23/6/26, 17/6/26, and 2/7/20.
You see, we had told you the dates, but we are not taking note of what we were saying. We had told you that you have taken these steps. We are referring to dates. You did not notice.
My lord, on 23/4/2026, my lord, case was fixed for submission of evidence on affidavit of DW3, my lord, and on that day, my lord, DW has been closed, my lord. And thereafter, on that very day, my lord, the case has been fixed for Lakmondal's witness, my lord. And for the first time, my lord, case was fixed on 17/6/2026 for the examination of Lakmondal, my lord. And I have, my lord, already, steps has already been taken, my
You
lord.
see, we have heard of temporary amnesia, where people don't remember of something happened in the past. When we are referring to page 21 for the third time, we are not reading page 21. No, what? Sorry, we are telling you to read it. Twice we have read it. We have told you to read it and you are saying you are sorry.
Opposite party, 4/3/2026, my lord. Opposite
11/2/2026. Do I have to shout for that? For making simple thing understand to you?
Opposite party absent, DW3 is present and cross-examined today. 6/4/2026 for submitting evidence on affidavit of DW3, my lord. That is not Lakmondal, my lord. That is not their witness, my lord.
So therefore, if you have 10 witnesses, After one witness is closed, you will file for second, then for third. So it will carry out for 10 years.
DW3 is the last one.
That witness has been closed.
DW3 is the Latmander, DW3 is closed, then Latmandal,
Latmandal is DW3.
Latmandal will be 3.
No, my lord. That model is not DW3, my lord.
This TW4.
DW3, they are relative, my lord.
You would have
That has
TW4.
You see, that is not the scheme. You will complete one and then take steps for second, then take steps for third.
My lord.
So if in this case you have 10 witnesses, you will take 10 years. For 3 witnesses, you have taken 2 years. For 10 witnesses, it will be 10 years. And the tribunal says you take steps and you don't take steps. There is nothing on record to show that you have taken steps.
DW3. On your prayer, the evidence of DW3 was closed.
And in order, my lord, in my additional legitimate, my lord, case 38, my lord, in 17/6/2026 order, that is opposite party son filed a petition.
Page number 36.
Is absent due to illness. Latmandal also could not appear before the tribunal as he received summon within short period of time. And praying for another date, my lord. That is for the first time, my lord.
17/6. DW3 was someone else,
Someone
but
other-
you wanted to adduce the evidence of DW3, but you did not.
No, my lord.
So you prayed for closing it.
Yes, yes.
It was
my lord.
closed,
Yes.
and thereafter Latmandal, it was
Yes,
fixed for
my
Latmandal.
lord.
And he did not come on the second date, it was closed
Yes.
on the second date.
Yes, yes.
So the time frame also, the tribunal was under pressure.
Ready to cross over, is it? 24/3, the case for Latmandar's witness. No. No, sir. 76/75 signed petition for the representatives, Latmandal was given the clear one is received. Some within a short period of time. Give me time, sir. Do happen. This much short time can you go? মানে তাতে short date, no? Six. But it's your default. You see, as per page 22, 23/4/2026, the tribunal permits you to call the Latmandal and says opposite party has to take steps. 23/4. Next date is 17/6. 17.6 is almost after 2 months. Then on 17.6, your son files a petition that Mandal could not appear before the tribunal as he received summons within a short period of time. Now, what would be short than 2 months?
That time would be close to days from 2 months elapsed.
Mr. Sharma, we give him a chance. We'll give a cost of 2,000 to be deposited in District Legal Services Authority.
And she paid. Will she be able to pay?
My lord,
Will she be able to pay? Yeah, will she be able to pay?
my lord.
Mhm. Good. Heard. Mr. S. Ahmed, Land Counsel for the petitioner and principal for the respondents. Next para. The case of the petitioner is that by an order dated 23/4/2026, the evidence of DW3 was closed, and on the prayer made by Land Counsel by the petitioner, the an opportunity was granted for examining the Lat Mandal as witness. And while directing the petitioner to take steps, the matter was fixed on 17/6/2026 for evidence of Lat Mandal. On 17/6/2026, the son of the petitioner had filed a petition. Amongst others, stating that the Lat Mandal could not appear as he had received summons within a short time. The learned tribunal adjourned the matter fixing 2/7/2026 for evidence of the Lat Mandal as a last chance. On 2/7/2026, as the petitioner could not produce the Lat Mandal for examination and had prayed for another date, the learned tribunal rejected the said prayer for adjournment and closed the evidence of the Lat Mandal. Accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 2/7/2026 passed by the learned member, Foreigners Tribunal -1, Bopeta, in FT case number 1395/2018, by which the evidence of Lat Mandal was closed. Next para. The learned counsel for the border and FT matters has opposed the player as the by submitting that the petitioner has been able to drag the proceedings beyond the period envisaged under paragraph 3 within bracket 14 of the foreigners within bracket tribunals bracket order 1964. Next para. In this case, the petitioner is not found to have taken steps at the initial stage when the matter was fixed for evidence, for calling the call for summoning all the witnesses. It appears from the order sheet annexed to the additional affidavit filed by the petitioner that after the evidence of one witness is recorded, the petitioner makes a prayer for producing another witness. In the considered opinion of the court, the same would be impermissible as he has to, as the petitioner has to disclose the to take steps for calling of all the witnesses, and in view of the period prescribed under paragraph 3 within bracket 14 of the foreigners within bracket tribunals order 1964, prolonging of the proceedings is not envisaged. Next, be that as it may, in view of the fact that the citizenship of the petitioner is being questioned, the court is inclined to take into consideration the same, and accordingly the order dated 2/7/2026 passed by the learned member from Foreigners Tribunal -1 from Calcutta is set aside. Full stop. Next para. Last opportunity is granted to the petitioner to produce all witnesses on whom reliance is placed, including the lat mandal, on the next date of listing. Yes, on the next date of the proceedings as may be fixed by the learned tribunal without any further adjournment. Next para, the petitioner, who is duly represented by his learned counsel, her learned counsel, is directed to appear before the Foreigners Tribunal -1, Calcutta, to give one last opportunity to the petitioner to produce all his witnesses. Next, petitioner is duly represented by his learned counsel, her learned counsel, who is directed to appear before the said learned tribunal within the outer time limit of 18/9/2026. And on that date, all steps for production of all witnesses will have to be taken. Next para. As the petitioner is found to be in default in taking timely steps for examining the witnesses, the court is inclined to impose a cost of ₹2,000 on the petitioner which is required to be deposited before the member secretary, District Legal Services Authority on Barpeta. $2,000. And the acknowledgement of receipt of cost shall be produced before the learned tribunal on the next date of appearance. Next para. It is made clear that as the order is being passed in the presence of the learned counsel for the petitioner, it would not be necessary for the learned tribunal to issue any notice for appearance of the petitioner. Next para. The petition stands allowed to the extent as indicated above. There shall be no orders to cost. No, don't say that. These are what to be subject to payment on cost as indicated above.
Some time limits also.
We have already said 314, we are already referred twice. They would know.
Originally,
That is why we have imposed cost, that they will understand.
reference was initiated in the year of 1998.
Yeah, that's that. 2,000. We will be rising, we will not be able to take up any other matter. Mr. Mahmood had made a request. We'll have it fixed day after tomorrow. Please inform Mr. Mahmood. Yeah. Yes, Mr. Chaudhary, you are there. What matter? Today we'll have to rise early, we'll not be able to take up. 44.
Treatment of party. Some other law, we have not take it up.
तो कभी लोगों करें कभी लोगों करो we'll take it up tomorrow. Item 44. Both sides are there.
I can inform my company,
Okay. Other matters will be court master will take a call. It was 44. The positive time matter could not be taken up today. Mr. B. Chaudhary, State Council submits that there is some urgency in the matter. As per list on. Make it tomorrow. Item number.
Few matter, my lord. First time just one. 1880. Date of opinion is my lord 16/6.
1515.
16/6, my lord. This year.
15, item 15. 30 May, okay. This issue notice, call for the records 4 weeks. Bail of rupees 5,000 to the extent to the satisfaction of
The border.
Morigao. Thank you. SP border Morigao. Item 16. Okay. Here also we should notice same order. Bail to the satisfaction of South Sarmara Mankar. Thanks again. Yes. Item 17. Twenty-eight, 325. So here you are not getting bail. No bail. Returnable date. New date. Returnable date after 4 weeks. Fair for bail shall be considered on the set of tribunal records. In the meanwhile, if the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court. So the petitioner shall produce certified copy of the order before the Superintendent of Police border, Goalpara, to bring the order to the notice of the said authority. Item 18.
My lord, it is 16/6/2026.
16,
6/2026.
26. Okay. Bail to the satisfaction of
South Sarmara, my lord.
South Sarmara Mankar. Any supplementary motion? Item 45.
Item 45.
Ms. Katagi? Huh?
46.
Not an FT matter. Okay. Okay. And this foreigners matter 46. What has happened here?
Amendment, the last occasion, my lord, is directed to move an amendment, because there are some dispute regarding the identity.
Oh, that identity. Okay, make it day after tomorrow.
Lordship, may I please, Lordship? Maybe, Lordship. Lordship, item number 33, Lordship. Here, Lordship, I am not on bail, Lordship, so.
Okay, that's really court master. He'll take
Yes,
care.
sir.
And Mr. Mahmood's matter also.
Yeah.
Day after tomorrow.